In this video, we are going to study Section 53A of the Transfer of Property Act 1882. I have provided the link of the previous videos in the description box, which you can check it out. So let's start the video. Part Performance. Section 53A of the Transfer of Property Act lays down that where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in part performance of the contract, taken possession of the property or any part thereof, or the transferee, being already in possession, continues in possession in part performance of the contract and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then, notwithstanding that, where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee, and persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession, other than a right expressly provided by the terms of the contract. Provided that nothing in this section shall affect the right of a transferee for consideration who has no notice of the contract or of the part performance thereof. Thus, this section provides that where any person enters into a contract for the transfer of immovable property for consideration by a signature signed by him or on his behalf, from which the terms necessary for the transfer may be made ascertained with reasonable certainty, and the transferee, in part in the performance of the contract, has taken possession of the property or any part of it, or the transferee already in his possession has taken some action in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then, notwithstanding that, where there is an instrument of transfer, and the transfer has not been carried out in the manner prescribed by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcement against the transferee, and the person claiming any right in respect of the property which the transferee has taken or continued to occupy, other than a right expressly provided by the terms of the contract. Provided that nothing in this section shall affect the right of a transferee for consideration who has no notice of the contract or of the partial performance of the contract. Section 53 of the Act imposes a statutory bar on the transferor to seek possession of the immovable property from the transferee in possession. Therefore, it disentitles the transferor from seeking possession from the proposed transferee in possession. Therefore, if the transferor tries to take possession forcibly, the proposed transferee in possession would be entitled to institute a suit to enforce the bar on Section 53A of the Act against the transferor. Therefore, remedy available to the prospective transferee in possession under Section 53A of the Act would be available only against the transferor that it with whom the prospective transferee had privity of contract, or in other words, who executed the agreement to sell in favor of the proposed transferee. Section 53A of the Act was added in 1929 and imports into India a form the equity of the part performance as developed in England. The following postulates a sine qua non for basing a claim on Section 53A. Number 1. There must be contract to transfer for consideration any immovable property. Number 2. the contract must be in writing, signed by the transferor or by someone on his behalf. Number 3. The writing must be in such word from which the terms necessary to constitute the transfer can be ascertained. Number 4. The transferee must in part performance of the contract taken possession of the property or any part of it. Number 5. The transferee must have done some act in furtherance of the contract. As to part performance, it is laid down that number 1. The transferee should have taken possession of the property, and number 2. The transferee being already in possession should continue in possession and should have done some act in furtherance of the contract. For example, payment of different rents or the spending of money because the possession may not be exclusively referable to the agreement. The most important limb of section 53A is the pre-existence of the contract. There should be a contract and number 1, it must be for consideration. Number 2, it must be in writing and signed by the transferor. And number 3, the term necessary to constitute the transfer can be ascertained with reasonable certainty. This right is more restricted than the English equity in two respects. Namely, number 1, there must be a written contract, and number 2, it is only available as a defense. As stated above, this section applies only to a case where there is a written agreement. An oral agreement will not be sufficient. This is a departure from the English law, for the doctrine is applied in England to payroll contracts affecting land which are not enforceable on account of the statute of fraud. Secondly, under the present section, the plea is available in defense and does not create any title in favor of the transferee. When the conditions mentioned in the section are fulfilled, it imposes a bar on the transferor from enforcing against the transferee any right or interest not expressly provided by the contract. So far as the transferee is concerned, the section confers a right on him to the extent it imposes a bar on the transferor.